number 147, People versus Charles K. Wilson. Thank you. Thank you, sir.
Good afternoon, Your Honors.
Good afternoon.
Excuse me. Kathy Reardon from the Monroe County Conflict Defender's Office for Mr. Wilson. May I request 2 minutes rebuttal, please?
You have 2 minutes.
In Justice Brennan's dissent in Harris, he observed, to the extent that Miranda was aimed at deterring police practices in disregard of the Constitution, I fear that today's holding will seriously undermine the achievement of that objective. The court today tells the police that they may freely interrogate an accused incommunicado and without counsel, and know that although any statement they obtain in violation of Miranda cannot be used in the state's direct case, it may be introduced if the defendant has the temerity to testify in his own defense. This goes far towards undoing much of the progress made in conforming police methods to the Constitution.
He lost.
He lost.
And the majority addressed that issue.
Your Honor,
Said that they weren't, while it might, they ruled that this was admissible. So isn't it really a case-by-case determination of whether or not there's bad faith in a particular case?
well, I think in this particular case, in our case, but I think also the dissent, he correctly foresaw that this was not going to be the situation.
But the Supreme Court hasn't changed the rule.
The Supreme Court has not changed the rule, but this
And
court...
we've followed that consistently for,
This court
what,
had-
45 years?
That's correct, Judge. You have, and I submit that this is a bold request to the court, but based upon, in one case that I'll throw out as Dunbar from 2014, that in fact this did not turn out to be the speculative possibility of police misconduct that they mentioned in
But
Harris.
they precluded there. So really this is a cross-examination issue, and it's coming in for cross, and the trial judge has broad discretion to preclude. In this case, which I think is a miscellaneous case that you cite here, it's a miscellaneous case where a judge precluded this cross, right?
That's correct, yes. It's a Monroe County
And
case.
within the discretion of the judge to say, you know what, under the Constitution, this is admissible, under the Supreme Court case and our precedent, it's admissible, but I find you did this in bad faith. I think the officer testified in that case admitted that this was his intent. Judge certainly could preclude it and did preclude it. Here, you have a line in a cross-examination of a detective witness say, I heard that, or I think I heard that. Judge doesn't preclude this. Why are we going to make a constitutional rule and overturn our own precedent to say you can never use this? Is that what you're asking?
Because that's what we're asking, Your Honor. And the reason is because I think at some point, if this particular client walks in there and he has read his Miranda rights and he unequivocally says, I do not wish to speak, that's it. And then they go ahead and they continue to interrogate him above and beyond. At what point do we say that's enough?
The trial judge says that's enough. The trial you can't use it. I mean, you can't use it in
On direct.
the Constitution says, you know, as interpreted by our court and the Supreme Court, you can't use that. So now it's a question of you can use it on cross. You can, but it's still within the discretion of the trial judge to exclude it as cross-examination, which was done in that one case you cite.
That's
so
correct.
why would we put a blanket rule in place so that in a case where that's not what happened, but maybe there's a defect in the Miranda warnings, or maybe he blurts something out, or there's some kind of casual conversation, we're now going to have a one-size-fits-all constitutional rule because of the case you give us as an example, which could be handled by the discretion of the judge?
Because I think at this point, Your Honor, and especially in this case, and I'll go back to it, he invokes that right. He invokes his right to remain silent. And he's understood that that's it. I have nothing further to say. This is where the interrogation ends. And we're submitting that anything beyond that, it's not a voluntary statement after that. He's
Yeah, but
being-
it gets a little more complicated when we were discussing this at the time. You have the right to remain silent. Does not mean that you can embellish your testimony at trial. Remember, when there's a number of those cases
Right.
where he says, well, what else happened? And he says, well, it was really in self-defense. And then somebody, well, you didn't say that, you know, when you gave your statement. And, you know, we get into that. So it seemed to me that there ought to be a rule. And this one came close because I think at the suppression, the questions were asked, you know, weren't you trained in this, right?
And there was discussion as to, it happens to be a lieutenant, retired lieutenant from the Rochester Police Department who wrote a book, We Get Confessions, and then had had taught courses apparently throughout the country exactly how to do this.
But you can't, I tend to agree with Judge Garcia that you can't simply say, all right, once the administration of Miranda rights and the invocation, everything stops, because, I mean, you can't underestimate the stupidity of some people. And if they just want to go on and talk, you know, you say, well, geez, now he's going high spill on the whole thing, but because I gave him the Miranda warnings, stupid me, you know, even though I didn't ask him, now he's given the whole confession, or something like that, right?
It's true, but at what point does, when they continue, after he says, I want to invoke, I have nothing further to say to you, and they jump back in and start asking him questions that are coming towards a confession. In this particular case, what they tried to get at was, do you know the co-defendant? Because at that point, there was no association between the two of them. They couldn't link the two of them together. And they instigated a conversation with him about this particular individual. And
Could the
asked
ruling
him,
then in that case, Judge Renzi, was it?
it was Judge Connell.
Okay. Could the judge have then said, one way or the other, you know, well, you know, he invoked, you continued, I'm not allowing this? You'd say, yes, that's you want the
Correct.
hard rule. But
Right.
it's also possible that you could say, well, that was just innocent conversation as he's getting up and leaving and going someplace, and I'm going to allow it. That would be okay, too, right?
Harris didn't discuss willfulness and intentionalness.
Right.
I think in this particular case, in the case that the court's referring to, but also in this particular case, I would submit that there was a willful and intentional
But you
violation.
want a rule that doesn't look at that. You want a blanket, bright-line rule post-Miranda.
Again, I think that's a bold request. I would like to see that happen because I think at some point this is just going to go on and on and on.
Should we not be concerned, Counselor, that that rule, such as you boldly suggest, would not be an invitation to fabricate testimony with impunity?
And that has been discussed in some of these cases, that it allows them to go in and perjure themselves. There are obviously other things that a prosecutor can do if that were the case. If my client in particular were to get up there and testify and say, yeah, I didn't know him, and then they go up there and say, well, you said that you did or you didn't, they certainly could bring charges for perjury against the
Perjury?
individual if he testified and
Could you
know,
use the statements in a perjury trial?
I suppose they might be able to. I mean, but then that would undercut, you know, the argument here.
Yeah, but if you're charged with murder, perjury is not your word.
But going back to just Judge Piggott's point, is following through on his question, it would be a post-Miranda rule. If you're Mirandized, you
Yeah,
invoke.
this is a little bit
Wouldn't
different.
that encourage, if now the next edition of I Get Confessions would be, don't Mirandize yet, kind of talk to them first, then Mirandize, and then, you know,
Which was done in Siebert.
Yeah, there's case law that says you can't do that, right?
Right, and that's exactly what happened in Siebert.
And you want to
They
avoid
taught-
this, you want to avoid the script you had in Dunbar.
Correct. Yeah,
So
exactly.
you're not going to be doing that.
Yeah, because they
Or
go
the-
in and they...
Not you.
They go in and they give this preamble and say, okay, you know, go ahead, we're going to talk to
Can you just perhaps clarify what, you've already told us what your, as the chief says, as you say, the bolder approach, the more narrow approach, which I understood to be that when you have police officers who are specifically trained and directed
Exactly.
to attempt to subvert constitutional rights, that's what makes this case of a different
And that's
tenor
exactly...
than the other cases.
And that's exactly what happened here. You've got willfulness, you've got an intentional...
Well, how is that, why isn't it just the police officers are informed of the state of the law? Because that's what we want. We want police officers to know the law, correct?
We want them to know the law, but we don't want them to go above and beyond the law. They know that if they go in there and they Mirandize this individual and he says, I invoke, they know if they continue and they get some sort of information and it's some sort of confession, that at the very least they can use it on cross or they can use it
Have we
at
ever
rebuttal.
looked at the subjective intent of the police officer?
We're not looking at the subjective intent, but there's, I mean, especially in this case, Ron, I would submit that there's an objective view that this officer, to his credit, the investigator did say, yeah, I'm familiar with this. I know what this is all about. And so they go ahead, and at the very least, they keep these individuals off the stand.
But he didn't go
Now-
the extra step, right? He didn't say, I know all about all this, and that's why I did it.
He wasn't asked the question, he wasn't asked that question.
And if he was, then the court, in its discretion, could have suppressed the statement, right?
The court could, I would hope the court would have
Counsel,
done that.
you
but-
started to say something, you keep these individuals off the stand. Were you making the argument that defendants would be precluded essentially from testifying in their own defense because they would be afraid of what would be
Certainly they
brought
are.
out on cross?
Certainly they are. And it's not just the content of the statement. In our case, it was, yes, I know him, no, I didn't know him. But then he gets up there, and the prosecutor would say, well, were you lying then, or were you lying now? I mean, essentially, it puts him in a position of, I can't get up there and testify in my own defense because of this statement, and that's
No,
exactly
you
what
can't
happened
get up
here.
and perjure yourself. Right, that's the law. You can't get up and perjure yourself.
Well, again, how he
You
would
can testify in your own defense, you just can't get up and lie because you risk that someone's going to point the lie out to the jury.
And then I guess the question is there a balancing act? What's more important? And I know the court has said, well, it's more important that, we prevent these things from happening. But at some point, the defendant's rights have to come into play. And I noted, and I understand I'm running out of time here, but in my brief, I noted that there was empirical data showing that this kind of thing has gone on, and the police are pushing it further and further. And at what point do we say, and maybe it's more fact-specific to this case, stop, you can't do this anymore?
Thank you, Ms. Shoemaker. Thank you. Counsel?
May it please the court, Robert Shoemaker for the people. Defendants' post-Miranda statements here were admissible for impeachment, for rebuttal, and to hold otherwise would not only overturn decades of precedent, but it would allow defendants to commit perjury unchecked.
If you do it intentionally, should there be some type of sanction?
Well, that's not the rule now. If it were the rule, that is not this case.
I'm looking for it. What do you think?
You think that, what do I think about this case?
No, and Judge Shoemaker, what would you do if they said, yeah, I knew, that he had a right to remain silent and he invoked it, but I also know that I can keep him off the stand if I keep him talking, so I kept him talking. And now he said he knew the co-defendant, and he's not getting on the stand, because if he does, he's cooking him goose.
Well, I don't know if it's appropriate for me to be making the new law, but the state of the law currently I would follow, and the state of the law currently is if it's voluntary, it's admissible.
If it's in bad faith?
As long as it's voluntary, it's admissible is what the case is.
Even if it's in bad faith?
Yes. Those are the cases that I've seen. I have not seen a good faith requirement in this state. I know some of the cases that are in appellant's brief argue for one, or there are in other states, but I've seen in this state, if it's a voluntary statement, I've seen where the police officer makes false promises, that leads to...
Here's the issue. If you do that, I think Ms. Reardon's arguing this, well, then why have Miranda at all? Why not say, we're giving you the Miranda warnings. You got them, you signed them, done. Now let's talk about your case. And he said, well, I don't want to. Well, guess what, pal? If you don't, you're going to be here all night. And you're going to be here all day tomorrow and the day after. So you better fess up. And what's he supposed to do? And then you get a confession. And you say, well, hey, the Court of Appeals says we can do this. And you're right, we can't use it on direct, but I guarantee you he's not getting on the stand.
So I guess I have three answers to that. One is the point of the Miranda in that case is that we can't use it for our case in chief, as we couldn't in this case. The other two things are if they do keep him overnight, all day and all night, that would be a prolonged
Well, I'm
interrogation.
exaggerating, but even go back to Dunbar. I mean, Dunbar was 15 minutes. I mean, just call them in and say, before we give you Miranda rights, we want to tell you, you got this opportunity to tell us, and they popped. I mean, we didn't like that either, because you're undermining the whole point of Miranda. And you don't want to do that, right?
Right, and in this case, what is supposed to happen with Miranda is what happened, is we were precluded from using this evidence in our case in chief.
Right.
We were allowed to use it for impeachment if defendant took the stand and lied. We
No,
can't
if he
just
took the
use
stand.
I'm sorry?
If he took the stand.
To impeach, we could use it to impeach him or for rebuttal.
If he took the stand. I mean, so he gets on and says whatever he's going to say. And said, by the way, didn't you also tell us that you knew that Boykins shot himself? So, therefore, isn't it also true? I mean, in other words, there's risk to the defendant about what you're going to do with a post-Miranda statement, right?
Right. Okay. There's definite risk, but as all the cases say, it's a balancing act. Miranda is important. The trial's truth-seeking function is more important. And that's why we allow these statements to come in.
No. I mean, I'm dominating this, I don't mean to, but if it was more important, then why would we have Miranda at all? If you say the truth-seeking is more important than Miranda, well, then why have Miranda? Why not just beat the crap out of him and get the truth?
We have Miranda to make sure that to make sure the statement's voluntary, but I really do think the cases say that the trial truth-seeking function is more important.
Should there be a different rule for statements that are simply unwarned versus, as opposed to the statement here in which there were Miranda warnings and then he was questioned anyway?
It might depend on the case, but I don't think there is a different rule, because I think Harris versus New York, the original case back in the 70s, was a case where there were no warnings. And in this case, there were warnings.
Counsel, you say these statements are admissible, but, for example, Nelson, which your opponent cites, it's a trial court decision, the judge precludes them under Harris and says this is a fact-specific decision, and making the appropriate balancing judgments as to future use, you can't use them for rebuttal. Now, you agree the trial judge has authority to do that?
Yes, absolutely.
Right. So it's not that they automatically come in, it's that they're not automatically excluded.
Right. It's that, I guess, constitutionally they are admissible. They don't necessarily...
Right. And I'm sorry, I'm having trouble finding it here, but what was the specific testimony from the officer, the law enforcement agent, as to his knowledge of this exclusionary rule or the use of these statements? Do you have it? Yeah, I have it somewhere, but I think just from remembering it, I've heard that. I've heard that's the rule. He didn't say, he wasn't asked, is that why you continued questioning him? It's, you're aware of the Harris rule, or that you're aware of the rule that if the defendant keeps talking after Miranda, you're allowed to use that for impeachment. And the officer said, yes, I heard that. He also did say that the instructor at his course, he said the name of the instructor at his course for the interrogation course that he took, but he didn't say that he was directed. He didn't say that he was trained specifically to do this. He just said the name of the person who instructed him. And like I said, there was no bad faith here. The defendant was never actually asked about the shooting itself. He was only kind of told, and I would say it was an innocent conversation, what he's being charged with, who he's being charged with. And then he kind of gives them a funny look, and they say, well, you know who that guy is. And so to not even ask them about the shooting itself, I think, shows that this was not in bad faith. If they really wanted to get at the heart of the matter, they would have asked him about this incident so they could keep him off the stand or impeach him on anything they wanted to. So this bright line rule that's being proposed might support the policy decision behind Miranda, but it would do so at the expense of all other judicial objectives, including maintaining the truth-seeking function of the trial. If there are no other questions, I will end my brief.
Thank you, sir. Ms. Reardon, was the record below developed to demonstrate or suggest that the interrogating officer was setting this guy up?
It was developed to a certain point, and then there was conversation about it, what they could be questioned about, what he could be questioned about in terms of what this individual had learned from Lieutenant Joseph, and then the court allowed him to get into it, and for some reason, trial counsel went off on another vein and didn't follow up on it after that.
So was there any testimony that was he knew that and that was his plan?
I think Ms. Shoemaker pointed out or reflected what the testimony was, which was basically defense counsel asked, do you know or are you familiar with this? And he said, yes, I'm familiar with it. And I don't have the exact language, he was rather coy, I think, in his, well, I'm aware of it. And I think it was pretty clear that he knew exactly what the purpose of this was.
And are you suggesting that Mr. Wilson's responses were not voluntary?
Absolutely. And I think that's our point. Once he invoked his right to remain silent, anything after that we're submitting it's coercive. I mean, he basically is being told, we don't care that you're invoking your right to counsel or your right to remain silent because we're going to go ahead and question you anyway. So at what point does that not become
Well, you need the bright line
involuntary?
rule for that, right? In other words,
I'm sorry?
You need the bright line rule, because if it's
Absolutely.
if it's good faith or if it was incidental, it could come in. well, Mr. Shoemaker wants us to come in no matter what, but there would be that. You don't want that. You need the bright line to say, no matter what is said, it doesn't come in.
And I think that's how I started out, calling it
Right.
bold, for lack of a better word. But I think when you get to that point, after they have invoked, if there continued to be questioned, how can that be considered voluntary?
Are you saying it's inherently coercive because you just keep talking to someone?
I do. I think it is inherently coercive, because there's no other
Is
reason.
that supported by our jurisprudence on this issue?
Hey, isn't that exactly rejected by?
And it is, and Harris doesn't follow it. I think however, under the New York Constitution, I think we have the court has a broader ability to address that issue and make a rule that would allow for something like this. And just to point out to the court, there's a statement in the prosecution's brief that said it would have been extremely odd for the police to have silently left the room after invocation of Miranda. And I submit it's exactly what the police should have done in the first place.
Well, don't they do that if you, well, maybe they do that. But it's a different story if he says, I don't want to talk to you, from him saying, I don't want to talk to you and I want my lawyer. Then we're very clear, right? The conversation ends.
Well, how is I don't wish to speak to you, or whatever the language he used, but it was not ambiguous. He was very clear. I'm not sure how that doesn't translate to the police. He doesn't want to talk to you.
Until he does.
Until he does, because
Until
he's
he does,
questioned.
because he's been notified as to what his rights are. He's been notified about the possibility that whatever he says could come back to haunt him, could be held against him, right?
That's correct, but he doesn't
But he may
initiate.
decide that perhaps something he says at that point will be very beneficial to him.
Well, in this case, there clearly wasn't
I
a
understand
benefit.
that, but we're talking about the voluntariness and whether or not you're, as I understood it, on another type of argument, which is under our state constitution, we should hold that continued questioning once a defendant invokes their right to remain silent is inherently coercive and can never be voluntary.
Well, I think that's initially how I started, and then I responded to Judge Piggott's question, but
Yeah.
he never initiated the conversation after he invoked. That came from the police, and that's when it should have stopped.
Thank you.